What are the phases in estate planning during your lifetime? Well, your circumstances are going to differ if you are a young family, or if you are in the middle of your working career, for example, or if you are retired. So the estate plan that you have is going to be different depending on what phase of life you are in. Let's take a young family. A young family might not have a whole lot in the way of assets possibly, but they do have children, and children are the ones you are wanting to protect with your estate plan. What I mean by that is that you need a will in which you designate who is going to be the guardian of your minor children in case you and the other parent are not alive. Somebody needs to raise your children. Who do you want that to be? You don't want family members fighting over who is going to be the kid's guardian. So make sure that you clearly indicate who that will be. Also, in the phase of your life when you are younger, you probably should be considering term life insurance. You want money to be there to pay for whatever the kids' needs are. So term life insurance is usually very inexpensive, and you're going to want to make sure that that term life insurance, that the beneficiary of that isn't necessarily the guardian of your kids. In fact, it shouldn't be. It should be the trust that is created by your will. And the trust will be for funds that will be for the benefit of your minor children. And the trustee of that trust, oftentimes we recommend that the trustee be somebody different than the guardian. That way there's balance between who is raising the kids and the funds for raising the children. Let's move on to, let's say you're in middle age and maybe your kids are grown now. So you're not going to need to have a trust that says who is going to raise your minor children. And you may not need any kind of trust at this point created by your will, dependent upon, what's your financial situation. In the state of Washington, we have a pretty low estate tax credit exclusion amount compared to the federal, for example. So in Washington, it's just over $2 million. The federal is over $12 million. So if your assets are below that amount, then you likely aren't going to need any kind of trust created in your will for purposes of estate taxes or anything else, for example. So in the middle of your life, that actually is where it becomes easier to pass assets either to your spouse or to others who don't need asset protection. Oftentimes in the middle of your life, what we're looking at is preparing an estate plan for you that will avoid probate. Even though you might have a will, which a will typically means there needs to be a probate. Let's say you are married, you want everything to go to your spouse with no protections. We can set up your estate plan even with a will to avoid a probate. And usually we do that through property status agreements and through how you set up your ownership of your bank accounts, for example. Oh, and one really important thing to keep in mind is if you have retirement accounts, those accounts will go by way of a beneficiary designation. So you want to make sure that it says it pays to your spouse. And then, for example, if your spouse doesn't survive, then the alternate would be to your kids. Let's move now to the phase in your life where you have retired and you have accumulated whatever wealth you're going to accumulate, most likely, and you are in that phase of your life where now you're more concerned about health issues. Not uncommonly, as people age, they have more health issues. The statistics as to the need for long-term care are kind of startling, that over 70% of people who are age 65 or greater will need some long-term care. So as an estate planning and elder law firm, oftentimes that's when clients will come to us very concerned because they want to make sure that they protect their assets for themselves and for their spouse when they're gone. The type of estate plan we will commonly do for people who are older and people who have concerns about health issues and long-term care will be different. This will be a will that will have an asset protection supplemental needs trust in it. I know that's a big long phrase, but what it means is when you die or when the first spouse dies, the will now come into effect. It will be probated. In the state of Washington, this is the only way we can protect assets for the surviving spouse against long-term care costs. So what happens is the first spouse dies, their assets will go through their will, through probate, into this trust for the surviving spouse. Any assets in that trust are protected against all threats, against threats of creditors. It's actually a tax protection trust as well. And most importantly, when it comes to long-term care concerns, assets in that trust are not counted by the state agency that administers Medicaid. When a person is a single person, a widow or a widower, Medicaid says they can only have $2,000 in countable assets. Well, with this trust, they can have their own $2,000 plus whatever amount is in that trust, because nothing in that trust counts as belonging to the surviving spouse, even though it's completely for their benefit, and the state agency won't let any of those assets in that trust interfere with Medicaid eligibility. So the surviving spouse, Medicaid doesn't count that money, the surviving spouse has the benefit of that money. They would be able to qualify for Medicaid despite having this nest egg, this safety net that's set aside for them. So my point is that the estate plan that is right for you, first of all, of course, it depends upon your circumstances, but just from a general perspective, the estate plan will be different depending on the phase of life the person is in.